AstraZeneca sought 80% of its costs, but as it had not been successful on all points, the overall award was that AstraZeneca would only have 50% of their costs to be assessed on the normal indemnity basis. In other words, indemnity doesn't mean 100% recovery on the legal costs, rather an award of the claimant's reasonable costs on an indemnity basis, usually around 70 to 80%. So to recap, it's important to bear in mind your end result when bringing or defending any claim for breach of contract. You'll need to consider whether you want to continue with contract or you want to terminate the contract, and this will determine how your case is framed. Damages will vary depending on whether there has been a breach of conditional warranty. Bear in mind any dispute resolution or dispute escalation clauses which may limit or postpone your right to terminate or bring proceedings. If you aren't able to escape the contract, then consider factors outside the four corners such as misrep, fraud or illegality. Think about whether you can also make a claim in tort or whether you need the protection of an interim remedy. Consider whether there are any guarantees or indemnities in place on which you can rely. And although it sounds smug, trying to avoid litigation in the first place, think very carefully about clear drafting of the contract and consider indemnities or try to resist giving indemnities and liquidated damages clauses depending on which party you're advising. Finally, your ability to enforce your client's rights will be fundamentally governed by the terms of the contract. Spare a thought for the humble jurisdiction clause, agents for service clause and choice of law. Even if you have the clearest drafting of your contractual and tortious rights, non-exclusive jurisdiction clauses will allow a foreign party to litigate in their own courts or potentially delay litigation for years, and yet they're often given little thought and frequently put into agreements which are inconsistent with a master agreement. Foresight at the drafting stage can dramatically improve your options should a dispute arise.
Thank you, Verity. We've just got a few minutes left for Q&A. We have had some questions coming in for us. The first question picks up on a point which I made in relation to guarantees, where I said that a guarantee has to be in writing and signed by the guarantor, and went back to the Statute of Frauds 1677. But somebody has brought us right up to date and said, hasn't there been a recent case about a guarantee being validly given by email? For that, of course, I'm going to turn to a young lawyer and ask Alex Beale if she can comment on that. Alex.
No, that's quite correct. The recent Golden Ocean Group Limited and Alcohol Mining Industries PBT case saw the High Court uphold the decision that it makes good commercial sense and is highly desirable that the law should give effect to agreements and guarantees made by email. Now, under the Statute of Frauds Act 1677, it's Section 4 that states for a guarantee to be valid, it must be in writing and signed. And what the Golden Ocean case has clarified is that so long as these two conditions are satisfied, an email can constitute a valid and enforceable guarantee.
So basically the email is treated as a form of writing. It's not the statute of frauds doesn't apply any longer. It's simply that the email is treated as meeting the requirements.
That's correct.
Thank you very much. And then Vanessa, one for you which ties in with something Verity was talking about, which is the status of liquidated damages in terms of enforceability. Why do parties get so concerned about liquidated damages and enforceability? What are the issues around enforceability?
Well, this is, Jonathan, where a party negotiates a fixed sum between the parties, and that fixed sum will be payable where there is a breach of clause in a particular contract, commonly seen in IT contracts. And this actually makes recovery much easier. It avoids the problem of having to prove actual loss. There's no argument over remoteness of damages, and there's no question of mitigation. It's effectively a straight debt claim. And parties get concerned because sometimes they can be treated as penalties if they are not actually a genuine pre-estimate of the loss of that party. So as long as they are a genuine pre-estimate of the loss, not a penalty, then yes, they're enforceable.
Great, thanks for that. And then just to close, one quick question which came in, which was about the scope of indemnities and whether an indemnity is enforceable, where effectively it's covering a loss arising from a criminal act, for example, the breach of the Bribery Act. The answer to that is that yes, an indemnity can be effective and enforceable in that situation, as long as the indemnity is not, as it were, procuring the criminal act to take place in the first place, so that it's not void for public policy. But it's quite frequent on, for example, a share acquisition, to have an indemnity covering a number of matters which might be very minor breaches, such as the Data Protection Act, through to more serious matters such as the Bribery Act, where the offence, as it were, which might generate a loss for the company, will have occurred on the seller's watch, and therefore the buyer wishes to be indemnified in that situation. Well, we'll need to close our Q&A session at this point. The PowerPoints that have been on your screens during the presentation will be emailed to all participants after we close. For those lawyers who've stayed the course, I'm pleased to say that this webinar is accredited and qualifies for 1 hour CPD. SRA accreditation code's on your screens now and will be in the pack that you'll be able to access by email. Our next SmartLaw webinar is on contract remedies in early July, just before we break for the summer holidays, and we'll send around the details of that event in due course. So I'd like to thank you all for participating today, and we look forward to you joining us